Hi, everyone. To those of you who have already joined, thank you for attending. I will get us started in just one moment at noon. Alrighty. It is noon, so I'm going to go ahead and get started. Thank you all for joining. We have a great webinar ahead of us. Thank you, Jared Anderson, Whitney Morgan, and Jesse Richardson for joining. APA Virginia is happy to support MAPC for this Guns, Lawyers, and Land Use webinar. As you can see, the CM number is listed here, 9258303. And we really do encourage questions, but please keep in mind to use the Q&A box to submit any questions. That way it's just easier for our panelists to keep track of everything versus the chat box. But if you have any logistical questions, feel free to reach out to me directly using the chat box. And then you may also use the raise hand feature to request to be unmuted to also ask your question that way. But without further ado, I will hand it over to, I have a quick poll for our panelists before they get started. So let me go ahead and launch that for you all. So the poll is, were or are you aware that the U.S. Supreme Court made a decision regarding the Second Amendment this summer that directly affects zoning? Alrighty, we're at 85% participation, so I think we can go ahead and share these results. So I will leave it up to the panelists to analyze this, most of you answering no. So I will hand it over at this point, but thank you all for joining and looking forward to a great webinar.
Good afternoon, everyone. My name is Jared Anderson, and on behalf of the Mid-Atlantic Planning Collaboration, we invite, or we're happy to have you all here today to talk about zoning and the Second Amendment and a bunch of other land use issues related to the Second Amendment. The Mid-Atlantic Planning Collaboration, this is just one of many webinars that the collaboration has done over the last couple of years anyways. And we invite you all to visit our webpage, and maybe we'll be able to share that through the chat or through Q&A, the link to the webpage, and you can view previous webinars on demand for CM credits if you missed any of the ones prior to. At this point, I am going to do the lawyerly thing and read a disclaimer for this presentation. This presentation is for education purposes only. The discussion is not intended as, nor does it constitute legal advice. Local governments are urged to seek legal advice whenever drafting regulations that may implicate Second Amendment rights. And with that, I will turn it over to Jesse and Whitney.
Thanks, Jared. I noticed that there are two questions in the chat box already. The first question, the CM number, I will get Jillian to post that or say that again.
Yep, I will be posting the link to the YouTube page as well. So yes, this will be recorded to watch later, and I will be also posting the CM number in just one moment.
Thank you, Jillian. And I'm Jesse Richardson, and I'm with the Land Use and Sustainable Development Law Clinic, along with Jared and Whitney. I am a land use attorney with the clinic. Whitney is a clinician, and the three of us, along with Christy Demuth, are the land use part of the side of the clinic, and we work with a lot of local governments across West Virginia, working on a variety of land use issues. And of late, the Second Amendment has been a big issue, one that we are getting into and need to talk about with our clinics or with our clients on occasion. So I am going to go ahead and jump in to the Second Amendment. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. And that short part of the Constitution has generated a fair amount of controversy, I would say, and particularly of late. And it's becoming increasingly contentious over what exactly that means. And many of us probably would assume that the Second Amendment really doesn't apply to zoning, but it does, and we'll talk about that. So let's talk about the United States Supreme Court decision in June. In New York State Rifle and Pistol Association versus Bruin. This is a case New York and 6 other states have kind of a extra requirement to their concealed carry permits. And even though concealed carry permits are not zoning, this does impact zoning in the Second Amendment. In New York State, the person who wishes to get a concealed carry permit must show that they have some special reason for wanting to have a gun for self-defense. So they can't simply say, I'm a citizen, I don't have a criminal record, I want to have a gun in my home and carry it outside of the property of my property in public to be ready in case I need it for self-defense purposes. The United States Supreme Court looked at this, and the decision really is a big change for Second Amendment jurisprudence. In the words of Justice Thomas, who wrote the majority opinion, the Second Amendment is no longer a secondary constitutional right. It's a primary constitutional right along with many others. And the court, a lot of lower courts have been saying that you look to see, number one, whether the regulation that the local or state government is engaging in is one that has historically been or traditionally been a regulation on guns. Secondly, you then apply either intermediate scrutiny or strict scrutiny to try to determine whether the regulation is sufficiently fitted to the purposes of the regulation. Well, in the Bruin case, the court said that second step, no more. You just look at the first step. And if the regulation is not analogous, comparable to a regulation that has historically and traditionally been in place, it's not constitutional. You don't have to go any further. And the court said that first, when we're looking at these core Second Amendment rights, And so what I just said applies to these core Second Amendment rights. Is it consistent with the traditional regulation? And then they said, well, self-defense is the central component of the Second Amendment right. And therefore, if the regulation imposes a burden on that right to self-defense, is a central consideration here. So basically you say, okay, this regulation, it imposes a burden on self-defense, but is this a comparable burden to regulations that were in effect at the time the Second Amendment was adopted? And in this case, New York pointed to 3 colonial era regulations that the state said, this shows that regulating concealed carry is traditional. And the court looked at those and said, well, the 3 regulations that New York points to, number 1, 3 regulations is a small number. Number 2, when you look at the regulations that local governments imposed that the state is bringing to the attention of the court, they really involved instances of banning people going into public places and waving a firearm threateningly, or carrying the firearm in a threatening way, or having some type of unusual weapon. And the court said in this case, it's clear that carrying a firearm, a handgun, is not any type of unusual regulation in these days and times. And if the person is carrying it in a concealed fashion and not using it to threaten someone or something of that type, then that doesn't really compare to these colonial era regulations. So what this means is that in the future, even for land use regulations, we're going to have to look at is, number 1, is what the regulation is burdening, is that a core part of the Second Amendment? And we're going to look at some of the cases and some of the things that talk about that. But I think for the most part, we're going to have to assume that it does. And if it does, then we're going to have to read history and look at historical precedent and see whether at the time of the Second Amendment was adopted, did we have comparable regulations? That's the other thing that New York State did. They did point to some early 1900s local ordinances on guns. And the court said 1900s is not the same as the time that the Second Amendment was adopted. Finally, I'm going to mention, and Whitney will talk about it more, and then I will talk about it more. One really hot spot for all of this is sensitive places. Places where handguns or firearms are not allowed. And the court said that in looking at these sensitive places, there are 3, and actually I think this is from Heller, but there are 3 places that are definitely, historically, you cannot bring firearms. That's legislative assemblies, polling places, and courthouses. And so those 3 are sensitive places within the historic tradition, and you can definitely regulate, ban firearms in those areas. For other areas, you're going to have to use analogies, or you're going to have to find other historic traditions to cover that. So that is Bruin in a nutshell. And we will come back to applying Bruin. Well, actually no cases of applied Bruin in a land use context at this point, but we'll look at some similar cases. But I'm going to turn it over to Whitney, who has developed some firearm regulation that we believe would withstand court scrutiny. But again, this is not legal advice today. So Whitney.
All right, so if you'll turn it to the next slide for me. You can go ahead. Yeah, thank you. So the Second Amendment protects the right to keep and bear arms. But what exactly does that mean? And more specifically, for our purposes, land use planning, how does the right to keep and bear arms intersect with land use? And within the sphere of what keep and bear arms might protect, there's a pretty wide range of rights that are going to be protected to varying degrees. So there's having a gun at home, carrying one in public, carrying a concealed gun, selling a gun between one individual and another individual, carrying a gun into certain businesses. And then we get into, the opportunity to buy a gun near your home or sell a gun at an expo. And then practicing using a gun, whether that's at home or at a shooting range. And these first 5 instances really are not going to be covered by land use law. If any of these are going to be affected by local laws, it's not going to be land use law. And much of that's going to be preempted by federal or state law. And I think Jess is going to talk a little bit more about that. The last 4, these are instances where the Second Amendment is going to intersect with land use, mostly zoning authority, but the last 2 also involve nuisance, possibly, insofar as noise is concerned. And I also wanted to say a little bit more about the 5th item, carrying a gun into certain businesses. Some land use law prohibits guns in particular zoning districts or within certain proximity to a sensitive use like a school. And that is land use, but banning guns from an entire zoning district is, I think, pretty decidedly too broad, something Jesse will talk about more. But this is different than prohibiting guns from being carried into certain types of businesses, regardless of district. I just want to point out that these are similar, but there's an important distinction to note in where the lines of land use law are in regulating guns. So next slide. So what are local government land use law concerns related to public health, safety, and welfare? Just to kind of frame our discussion. Discharging a firearm for target practice, whether that's at an indoor or outdoor shooting range. Nearby sensitive uses, we've talked about that one, like churches or schools where people regularly congregate and may need quiet spaces for learning or worship. Sound more generally can certainly be disturbing to any nearby uses, people dining outdoors, or just even residences. There may be some concerns about gun uses and hours of operation, particularly when sound comes into play. There can be some pretty intense lighting associated with outdoor shooting ranges that allow practicing in a nighttime environment. There's aesthetics for either indoor or outdoor facilities, especially at a commercial level. And then storage of waste can be particularly important insofar as lead is concerned. So next slide. So how can local governments regulate to address these concerns? The first thing I'm going to focus on are the uses, shooting ranges and gun retail. And I want to emphasize that all regulation is subject to rational basis review. This is different than complying with the Second Amendment. It basically means that you have to have some reason for regulating besides, I don't like guns, or I don't like the sound of guns. And so for that reason, when you're thinking through districting or when you're thinking through the uses, the best practice for retail is to treat gun retail the same as other comparable retail, except for the setbacks from sensitive uses. And what constitutes sensitive uses is complicated, but Jesse's going to take that on shortly. It's also important to treat the same sporting goods stores that sell guns as a portion of retail sales, and gun stores that sell guns as a focus of retail sales. At least gun stores that sell guns as a focus of retail sales, so stores that are primarily guns and ammo shops, they shouldn't be treated less permissively in districting than sporting goods stores that also sell guns. There's at least one court case out there that's found no rational reason to treat them differently in zoning. And then a similar approach should be taken with gun expos, in that they should be treated the same as other large events, again, with the exception of setbacks from sensitive uses. So beyond retail, we also have shooting range uses. And the way we've been thinking about them, and Jesse, you can go to the next slide, in ordinance drafting at the land use law clinic at WVU is in 4 types: indoor commercial, and outdoor non-commercial. So you can see on the right an example of an indoor private shooting range in someone's basement, right next to their basement kitchen. And on the left are some examples of commercial outfits where people can pay to do target practice. And then the next slide, there's also outdoor shooting ranges that people may set up for their own private practice in their backyard or on land they have out in undeveloped areas. But you also have these larger commercial outdoor practicing facilities where people can pay to do target practice outside. This is kind of what the uses look like. And at least in our categorization of uses, the commercial non-commercial distinction hinges on whether there's a fee to shoot. And you can actually go back for just a minute, Jesse. So just looking at these images and thinking through the various ways that people are going to want to practice shooting indoors or outdoors, how can local governments make sure this is done in a way that is safe for their communities and compatible with how they want their communities to be without running afoul of the Second Amendment, and also even just rational basis review? So first I want to talk about districting the different uses, and then I'll get into the safety aspect. For the non-commercial or private shooting ranges, those that are outdoor, non-commercial outdoor shooting ranges generally should be a permitted use in all districts because of essentially each landowner's right to shoot on their own property as long as they're doing so safely and in compliance with reasonable governmental regulations. And at least in West Virginia, our state code has setbacks from homes that would generally prevent shooting in densely developed residential areas. I'm just going to talk a bit more about those types of state preemption. Then for the non-commercial or private indoor shooting ranges, these should also be permitted in all districts, but they can be either permitted or conditional use. Noise limitations are going to prevent shooting in densely developed areas, typically unless the structure housing the indoor shooting range is constructed to contain considerable sound. And to the extent these may be placed in accessory structures, the standard accessory structure limitations should apply. Again, there's no rational reason to treat these differently than another basic accessory structure in terms of where they can be located and such. And then for the commercial shooting ranges, the outdoor ones, that's an important point on the commercial shooting ranges for indoor and outdoor. But for outdoor, they can be districted in areas that are suited for the intensity of the use. Commercial outdoor shooting ranges, they can be made conditional, but probably a more prudent approach would be to allow them as permitted, but with detailed supplemental provisions that address community concerns to avoid inviting personal bias against guns into the conversation. So with conditional use permits, that is always a risk. It would make sense to look at how comparable recreational or sports uses are permitted within a jurisdiction and deciding where to allow outdoor shooting ranges. And then similarly, commercial indoor shooting ranges, while they can likely be excluded from like residential districts and placed in districts that are more suitable, looking at comparable uses, it's sort of like a RLUIPA analysis in terms of churches and places of assembly. The analogy being, commercial indoor shooting ranges, you might look at where you have bowling alleys or similar, sort of noisy indoor recreational uses and mirroring where those are allowed. So like commercial outdoor shooting ranges, they can be indoor, can also be conditional or permitted by right, but maybe the better practice would be permitted with supplemental provisions that address community concerns. Okay, so next slide. So this is where we've done I think a sort of interesting approach to safety with shooting ranges. So beyond districting the uses, the next thing I want to talk about is the utility of performance-based standards to achieve safety for shooting ranges. So performance-based standards may be more reasonable from an enforcement perspective, since they focus more on desired measurable outcomes rather than detailed processes and procedures to reach desired levels of safety or even sound. They can be more easily enforced. And that's the appeal, their simplicity and enforceability. So for example, in the case of shooting ranges, rather than enacting zoning regulation that details the stringent engineering required of an indoor shooting range to achieve safety and appropriate sound levels, instead, a local government can create two performance-based zoning standards, one that requires buildings, housing, and you can go to the next slide on this one, Jesse, that requires buildings, housing, an indoor shooting range to be constructed such that a bullet cannot exit the building, appropriate decibel levels at property lines and the nearest right-of-way. The performance-based standard approach to shooting range regulation leaves the design and engineering to the property owner or developer, and then allows local governments to focus on measurable concerns it has for neighboring properties or various neighborhoods. And so specifically, for example, if a bullet exits a building or property, that's going to be a fairly easily observed event, especially if it makes contact with a structure on a neighboring property. If you go back, Jesse, there are a couple of guidebooks I'd point to as informative of how to create safe shooting ranges. Delving into these was a bit why, we as a clinic that often serve rural local governments with limited capacity, thought maybe we needed to regroup on how to structure ordinances that were manageable. These guidebooks are great. The NRA's range source guidebook is something that must be purchased. It has a lot of detail on how to regulate shooting ranges, I believe both indoor and outdoor. And then the US Department of Energy has one that's publicly available on range design criteria that also can be informative. And these could certainly be made available if you take on performance-based standards, but then have developers asking questions about how to achieve the level of safety or sound requirements that you're looking for. They're a good reference point. So for the most part, performance-based standards should apply uniformly to all uses, not just shooting ranges, within a given district or as a distinction made between residential and non-residential uses. So for example, a major concern of local governments is the sound resulting from shooting ranges. Jesse, you can go forward 2 slides. But no rationale exists for having explicit decibel limitations for shooting ranges, but not for all other equally sound noxious uses that you're going to find in a community. This is another instance where gun regulation just fails rational basis review. There are many loud indoor and outdoor uses that create noise at the same level as guns. And so if a community wants to limit sound from shooting ranges, sound provisions should apply to all uses, not just the shooting ranges. And with sound regulations, some things to think about are the decibel limits at the nearest property line and nearest right-of-way. which are easy enough, I think, to measure. And then, but also thinking and continuous sound, which would need to be defined. And there's some material out there to look into what would make the most sense for your particular community, but there is a distinction between intermittent and continuous sound. And then also thinking about whether the limit should vary, the decibel limits should vary between daytime and nighttime hours. What's interesting about taking a performance-based approach is that setbacks are achieved indirectly, but for a pretty clearly legitimate end. So the notion that outdoor shooting ranges must be constructed such that a bullet can't leave that property, that's going to require the landowner or the developer of a larger facility to have setbacks or buffers that achieve that end. And that may be more defensible than just arbitrarily establishing setbacks or attempting to establish them, through complex research on safety and sound and how sound travels over different terrain, and then, even more complex in how that translates to a given property. Then the next slide, Jesse. Another thing I wanted to note is the waste contamination and storage of lead specifically. If you look at the detailed guides I mentioned earlier, NRA's guidebook and the one from the Department of Energy, there's quite a bit of mention of safety surrounding lead. And while quite a bit of that is beyond the scope of zoning or even nuisance, another performance-based approach to consider is this one, that all waste potentially containing lead or other toxic materials be safely stored such that contaminants don't leave the property when accumulated, rather than getting into the details of how that'll be achieved. It's more measurable if the non-compliance occurs for an enforcement officer. There's also, I mentioned how setbacks can naturally be achieved, but then there's the setbacks from sensitive uses and nuisance issues. This is likely going to interact with state limitations and on, maybe setbacks from homes like we have in West Virginia for firing a gun. So I'm mostly reserving that for Jesse. But before I turn that over to him, a part of the conversation in talking through how to regulate guns and zoning and what is not land use, what is not zoning. So local governments rightly have other concerns when it comes to shooting ranges, like safe gun use within the shooting ranges, or employee safety, or age restrictions, or even drug and alcohol use. However, it's important to, those issues go beyond the authority of typical local land use, in particular zoning. It's really important to understand the boundaries of land use law when it comes to gun regulations, because reasonably so, there are wide-ranging concerns related to guns, and so there's a lot of ways local governments may want to regulate. But when working on developing local land use law, you have to stay within local land use authority. And with that, I'll turn things back over to Jesse.
Well, Whitney, if you don't mind, there's a number of questions. Maybe a few of those might be good now, or would you prefer to wait until the end?
I can take them now, and if do you mind, and I'll if you filtered them, okay.
Yeah. Is fee to shoot different than a membership to a shooting club?
The way we've defined the uses, no. If there's because I do know that is financially the way some of these are structured, that rather than pay to go shoot a single time, there's a membership. So if there's some exchange of money to be able to shoot, then we categorize that in our definition of uses differently.
And one question says, did I hear you say that outdoor discharge of firearms should be permitted in all districts? What if discharge of a firearm is prohibited within a municipality?
Well, that's probably better answered by you, Jesse.
Yeah, and I would say probably prohibiting discharge within a municipality. Bans are generally not going to be upheld. And if that prohibition includes discharging a firearm for self-defense, it's definitely not going to be upheld. Yeah, and maybe I'll talk about that a little more later.
Because Bruin was about a ban on an entire city.
Yeah, and so it seems like that right of self-defense is the core of the Second Amendment. And another question says, well, wait a minute. The Second Amendment says well-regulated militia. But I think the Supreme Court has interpreted that to mean that basically the government can't take everybody's guns away, because then there would be no way to defend against the government. If the government tries to become basically, take over all of the citizens' rights.
Well, and if you really want to dig into the militia component of the Second Amendment, I believe it's Bruin, if not Heller. I believe it's Bruin, though, spends a long time parsing out the English language with regard to the structure of the sentence in the Second Amendment. So at least if you'd like to know how the current Supreme Court's interpreting that, that is well fleshed out. And
Yeah, and
the
that's
result being that it's that the right to bear arms is basically that I think they interpreted the militia component to just be sort of an aside. It's not a limiting component to the right to bear arms in any way, shape, or form.
And that's Heller, and that's, you had commented on Justice Scalia's opinion in Heller and how it really dissected every word. I think you answered this. Are there good examples of standards for indoor and outdoor shooting ranges that municipalities can look at?
Yeah, I mean, definitely look at the NRA book. There's a cost for that one, but I believe it may have been wrongly published somewhere in communities' ordinances, so you may be able to get access to some of it that way. But the just the Department of Energy's material is excellent as a starting point to see the level of concerns. I mean, when we were looking at it to develop ordinance language for one of our communities, just the number of additional definitions and new terms was extraordinary, much less the details of the regs.
And you talked about storage and contamination. So Andrew had commented on that before you talked about that, but that could include things like material safety data sheets. But you were talking more about a performance standard that says just ensure that none of it leaches out, correct?
Yes. So once it moves on to another property, that's when a zoning violation would occur, and then the consequences would begin. And our perspective is often ease of enforcement, but it also can be helpful to take performance-based approaches with something like gun regulation, because not only is it more easily enforced, I think it's arguably more defensible, because it's the harmful measurable outcomes that trigger a violation.
And we got a ton of questions. I'm gonna give you one more, Whitney, and then I'll give you a break. But Tracy has an interesting question. When we talk about noise, many firearms can be noise suppressed. And so Tracy says, well, why don't we regulate it based on, I guess, end of gun suppression as opposed to structural?
Well, that's not land use law.
And I think I would say that under your performance-based approach, if the owner of the shooting range wanted to require noise suppression on any firearms shot within that shooting range, that would be one way to address the issue.
Yeah, that would be a method that someone privately shooting, or if someone has a commercial venture, that they could achieve their noise level requirements. But I mean, zoning could get into the structure, how the structure's created and insulated, and the safety all kinds of safety and structure measures. But once you start regulating like the way the guns are, from what land use authority is, and that seems problematic.
Okay, thanks, Whitney. We will get back to you in a little bit. Lots of great questions. I'll try to answer some of those when I talk about the items that I'm talking about. I think I'm about to really blow some minds here, because we're getting a lot of questions on the ability to regulate shooting ranges and things like that. And I actually did not know this until a few years ago. There was a West Virginia case on this. Then we got a student to look at it and found out that this is pretty widespread. But number one, there are a lot of state statutes that address local regulation and preempt local regulation based on the sound of shooting ranges. There are state statutes on firearms that limit the ability of local governments to regulate firearms in a variety of ways, other than land use, but sometimes including land use. 48 out of the 50 states have a statute on shooting ranges, and I'm going to talk about that in a second. I call them right to shoot statutes, which Whitney doesn't like that title. The reason I call them right to shoot statutes is, if you're familiar with right to farm statutes, these statutes are very similar. And they address nuisance, they address local regulation, and there are some similarities in these. And every state but Hawaii and Washington State have these state statutes that preempt at least some local regulation of shooting ranges. And a lot of them go to nuisance as well. Just like the right to farm statutes. I have two examples here, West Virginia and Virginia, but they're very similar to the statutes. It looks like, somebody enacted this and then it spread throughout the United States. In West Virginia, as it applies to outdoor shooting ranges, and basically says, if the shooting range was there first, it can't be a nuisance. It also establishes a 2-year statute of limitations so that if the shooting range comes in, if you think it's a nuisance, you have 2 years to file a lawsuit against that. And this is similar to a lot of the state statutes as well. If there was a local noise ordinance at the time the shooting range was established, and the shooting range complies with that, you cannot get injunctive relief for noise. And that seems to be a theme. You can't change the noise rules after the shooting range comes in. And we had a couple of questions kind of related to that. I know one question we had was, can I, in rural areas, we often don't have noise ordinances. So can I pass a noise ordinance that just is looking at shooting ranges? And the answer, I think, is pretty clear, no. From what Whitney said, and from the cases that we read, if you want to regulate noise in your community, you have to treat shooting ranges just like every other generator of noise. You can't single out shooting ranges for special treatment. And a lot of these state statutes preempt you from doing that anyway. I'm not sure if they're based on the Second Amendment or where they came from, but it's very interesting, I think. For local ordinance, you can have no noise ordinance more stringent than that was in effect at the time the shooting range was established. And we do have a case on that in West Virginia. And finally, and this I find really interesting, almost all of the statutes say, I guess this is getting at local governments trying to eliminate shooting ranges. They say if a shooting range is condemned, taken by eminent domain, that owner of the shooting range has the right to relocate somewhere else in the locality, and they are still grandfathered in on the same basis they were at their original location. So I think they're trying to prevent backdoor ways at getting rid of shooting ranges. Virginia, kind of similar. You cannot have a valid nuisance claim based on a shooting range in Virginia, based on noise, I'm sorry. No injunctive relief based on noise. Just like West Virginia, no noise ordinance more stringent than that in effect at the time of the effective date of the shooting range. And they go further and they focus on noise a lot. No injunctive relief, no criminal prosecution for noise if the shooting range complies with the noise ordinance at the time that it was begun. And I think the case in West Virginia, there was no noise ordinance, so obviously when it started, so the community can't come in later and put a noise ordinance in when they didn't have one at the time that the shooting range begun. And West Virginia has that condemnation provision as well. So I'm going to talk about a couple cases and then we want to answer some more questions. There's a lot of questions. I want to emphasize at this point, since Bruin was decided in June, the only land use cases that have come up since Bruin are cases where the court has said, okay, Bruin has been decided. I'm going to send this back to the lower court and you consider this case based on Bruin. So we don't have any land use cases directly on point after Bruin, but we're analyzing the case and telling you what we think will happen in the future. And this Drummond versus Robinson Township case, it's before Bruin, but it's a very good case. I think the court made the correct analysis at the beginning of the case when they were looking at doing step 1. Now they went on to step 2, which the court now says there is no step 2. But I think Drummond's step 1 was very well analyzed. And this is out of Pennsylvania. For whatever reason, Pennsylvania has a lot of these gun cases involving land use. So we had a sportsman club, which one of the questions was about. And it seems like that sportsman club kind of stopped operating, or there was a pause. Somebody came in and leased the property, and they were going to continue the gun club. Some of the neighbors saw this happening and went to the local government and said, we don't want the gun club, the sportsman club. And so the local government amended their zoning ordinance only for these sportsman clubs in an interchange business district, which happened to be the district that this property was in. So it was pretty clear that they directed these changes at this particular property, which is problem number 1. And what they did was they said centerfire rifles are prohibited, and only nonprofits can own a sportsman club in this district. And the court looked at the historical evidence, like the Supreme Court has directed us to do, and looked at long-standing traditions, and looked to the question of whether a particular type of regulation has been a long-standing exception to the right to bear arms. Now, another thing that I find fascinating in this case, good example right here. They said, here's an example. Back in colonial times, the sale of gunpowder was regulated. We regulated the location of the sale of gunpowder, and we regulated the amount that you could sell at one time. And the court said, well, that makes this analogous to new, like high-powered rifles or magazines that will hold numerous bullets. And they analogized it and said that, so this is a basis for some modern regulation. And even Justice Thomas in the Bruin case said that the modern regulation doesn't have to be a dead ringer for the historical precursor, but it has to be analogous enough to pass constitutional muster, whatever that means. And they said, well, local governments have long restricted the location of sales and the location of shooting ranges. And so something that might make you feel better, and I think Whitney agrees with me, that you can regulate the location of where guns are sold, and you can regulate the location of where shooting ranges are, but there are parameters on the extent of that regulation. But the court said, distinguishing between centerfire rifles and other type of rifles, there's no tradition for that. And frankly, what's the rationale? And the court said, same thing for nonprofit ownership. What difference does it make from a land use impact, whether it's a nonprofit or a for-profit? And so the court said these are not long settled traditional regulations. Then they went on to the second step, which I think today is gone. I think the result would be the same, that those regulations are not permissible. There's another case before Bruin, which I think is instructive. Chicago banned shooting ranges, and bans, I think, again, are not going to be upheld. And that was overturned. So in response, the city enacted several regulations. They limited shooting ranges to manufacturing districts, and you had to get a special use permit. And they said there are setbacks from another shooting range, from a district that is zoned residential, places of worship, and various other places. Prohibition on people under 18 from entering the shooting range as well. The court said these regulations are not reasonably aimed at protecting public health, safety, and welfare. So in other words, you don't have a good enough reason to do all of these. Now, again, some good news to this, I think. Chicago also enacted some safety regulations, which were fairly similar to the performance standards that Whitney talked about. The court upheld those, said those make sense, and there's no problem with that at all. So that was upheld. Somebody asked about where can I find a list of sensitive places and whether they are allowable or not. There is nothing definitive. But New York tried to get in under Bruin, and the United States District Court for New York has already decided on this on October 6th, less than a month ago. If you look at this Antioch versus Hochul case, the footnotes are wonderful, because the footnotes go through all of the history of these as sensitive places. And here's what they came up with. Now, I'm not saying that this is the gospel, but I think it will be upheld on appeal, but who knows? Those basic, control, if it's controlled by the government, that's a sensitive place. Polling places, sensitive place. Public areas with restricted access, sensitive. Places of worship. However, there is an exception for that. People like police officers are allowed to bring their guns into places of worship. Schools, colleges, universities, and public assemblies, those are all sensitive places. However, summer camps are not. Public transportation. That surprised me a little bit, but public transportation, not. And when I read the court opinion, they said, hey, public transportation, you might need to use your gun for self-defense when you're on public transportation. Entertainment with alcohol. New York also tried to designate Times Square in its entirety as a sensitive place. The court said, no, that's too broad. And that goes back to what Whitney was talking about. The larger the area, the more likely the court's going to say, that's a little broad as a sensitive area. Healthcare facilities, libraries, parks, family services, disability programs, homeless shelters, residential health settings, all were considered not sensitive areas. If you want to read up on sensitive areas, the footnotes to this case are wonderful to do that. I know we're up against time. Whitney and I will stick around to answer questions as long for a reasonable amount of time. I want to do one or two more cases. Another Pennsylvania case, and this gets at a question, how about shooting ranges and practicing? In this court, at least, and I think the Supreme Court would follow suit, they said that what good is a right to self-defense if you don't have a right to practice shooting guns and to practice gun safety so that you can be proficient at it. And we had a question related to this. In this township, they said no shooting ranges except in particular zoning classifications. And the court there was pretty snarky, actually. The court said, we don't really think that there shouldn't be shooting ranges in all of this township except these particular areas. So what Whitney was talking about with respect to banning personal use shooting ranges, I think this court would agree with that. Now, there are some old regulations and some old cases that say that there are traditional historical regulations that say you can't shoot a gun in a heavily populated area. You can't shoot a gun in somebody's front yard. I think regulations like that will be upheld, but broad regulations that say you can't have a personal shooting range anywhere in a residential area are probably not. That's where you need to use some performance standards or something else to say you can have it, but it has to be safe. Bans are not likely to be withheld. It's important to look at the activity, the effects, not the activity itself. Guns have to be treated like any other activity. Reasonable setbacks from sensitive areas are probably going to be upheld. And local governments are going to have to be ready to analogize their regulations to historical traditional regulations, and they're going to have to be ready to bring evidence to court to support the rationale. And that's basically, why did you pick this particular regulation, and why could you not do something, or what would happen if you don't have this regulation? John asked the question of, can we look at crime statistics or something like that and say, well, that supports a gun ban in this area? I think you can't. I think you have to tailor the regulation more strictly to minimize the burden on the Second Amendment right. And I know we had a lot of questions that raised issues with that, raised concerns about that, but the United States Supreme Court has ruled on this, and you should care because that's the law of the land. And if you enact an ordinance that doesn't comply with this, you may well go to court and it might be struck down. Whitney, do you want to say anything at this point, or should we go to questions?
I'm ready to do questions.
Let's see what we got. Let's see.
The question about churches and shooting ranges being entitled for the same deregulated zoning approach. To the extent I analogize to churches, the thought I had is that, RLUIPA asks that, or RLUIPA case law shows that churches need to be allowed where other places of assembly are allowed, and that's distinct from saying that shooting ranges should be allowed where analogous outdoor loud events are also allowed, or saying that indoor shooting ranges should be allowed where similar loud indoor recreational type uses are allowed. I'm definitely not saying, I think maybe that gun uses need to be allowed to the same extent that churches. I'm just saying that analogy, I think, is going to be helpful if there's a challenge. And that thought process is going to be helpful if there's a challenge.
I agree with that. And I'll go to a question by Eric because he raises an issue that I wanted to talk about. Does the recent Supreme Court case prevent the national park system from prohibiting guns in their parks? No, because we're talking about regulating guns as a government now. That's different than regulating guns as an owner. So if the local government owns a building, they can ban guns in that building as the owner of the building or as the owner of the property. Another note, homeowners associations are not bound by the Second Amendment. So you could have covenants and restrictions that ban guns or regulate guns, and that would be acceptable as well, but not government regulation. And still the state can put some restraints on what local governments can do even as an owner. Let's see. Joseph said, how does a shooting range comply with a noise ordinance at the time the use was established? What that means is if I establish my shooting range on November 1, 2022, if anybody complains about noise in 2028, what the court's going to do is say, what was the noise ordinance on November 1, 2022? Does the shooting range in 2028 comply with that ordinance? If it does, it's allowable. So if the community comes in a year later, 2 years later, changes the rules, shooting range does not have to comply with that new rule.
Another one I'm seeing is that a lot of localities don't regulate noise in rural areas where the shooting ranges and private shooting ranges occur. There's a noise ordinance for firearms, and we're stepping into the same issues with trying to regulate the Second Amendment. The idea is that, and I hope we made this point that, or something that we definitely need, that needs to be a takeaway, is that if you're going to regulate noise for firearms, you have to regulate noise for everything. You can have a noise ordinance. A lot of communities have a nuisance ordinance that's going to encompass noise disturbances, but it might be more helpful and more enforceable to have a noise ordinance that more specifically lays out decibel levels where they're measured at the nearest property line to the activity, at the nearest public right of way, distinguish between constant and intermittent sound, and have levels for nighttime and daytime. And that applies to everything. That applies to guns, it applies to tractors, it applies to wind turbines, it would apply to everything.
And John asked about how does this compare to adult businesses or sexually oriented businesses? I think it's comparable in a way, but I like the church comparison better, the church analogy better. But because on sexually oriented businesses, you can do your research and come up with a lot of journal articles and data that shows that sexually oriented businesses create crime, blah, blah, blah. And you can use that to regulate it, but guns are similar to SOBs in that you can't ban SOBs. And you can't be unreasonable in your regulation. You can't just say, I don't like SOBs, so I'm going to limit them to industrial areas where they're not going to be anyway. It's also kind of comparable to sign ordinance in a way, because they're all constitutionally protected.
Right, and I think I think it's fair to say that, you know, even as much as we've tried to portray what the new analysis is going to be, it's still kind of convoluted. We're used in regulating, and I even still talked about that in my presentation, thinking through, but proving up the governmental interest is not as much a part of the conversation with guns anymore and regulating. It's now the history of regulating, and that still has a governmental interest component to it, but it's going to be overridden by the history of regulating. And I just wanted to add that in.
Yeah, and for the lawyers out there, people who are interested in this, I kind of think when we're starting to analogize modern day regulation with traditional regulation, a lot of the same concepts are going to come in. So I'm not sure how different this is going to be. Nobody does at this point. I think I'll take one more question. Preston asked a good question. In the Hochul case out of New York, public assemblies are sensitive places, but entertainment areas with alcohol are not. And in a lot of places, you have entertainment in a place of public assembly. So would that be a sensitive place? And I would say if it is a public assembly, it's going to be a sensitive place. The fact that it happens to be entertainment with alcohol would be secondary at that point. But he also says, will this list that come out of that case continue to be vetted? And the answer is yes. So this is going to be a constant evolution where these things are going to continue to evolve, and we'll know more later on, I guess. And I don't know, Eldon, did you want to say something?
I don't believe Eldon is on this
Okay.
afternoon, but we are really pleased with all the questions. Great questions. I will be sending out, with the panelists' permission, I assume, emails, your emails in the follow-up e-blast to attendees if you did not get a chance to ask your question, or if they didn't get to your question. And we will also be sending out a copy of the slide deck and links to the YouTube page and to the web page.
Thank you, Jillian, and thank you all for coming today. It's an interesting area that will continue to evolve.
Thank you, everyone.